iDS Talks is a podcast dedicated to helping corporations and law firms find new and effective ways to leverage data, giving them a decisive advantage both in and out of the courtroom.
Hello, everyone. Welcome to another edition of iDS Talks. Today, the topic is intellectual property one-on-one, protecting your business in the digital age. I am Teddy Brown, a managing director with iDS in the forensic accounting and commercial damages group. And I'm here and joined by Mike Perelman. Mike, why don't you introduce yourself?
Hey, everyone. And Teddy, welcome. I understand this is your first iDS Talks. So
it is.
Looking forward to this great conversation. I'm a director at iDS with a particular specialty in IP theft, departed employee theft, and I'm also a testifying expert in digital forensics.
It's great to have you here. It's great to be here for my first iDS Talks, and looking forward to a great conversation on intellectual property and the Lanham Act and what we are seeing in the world today. So I'm going to get started just quickly with a diving in a quick overview of intellectual property. As I see it and as we see it at iDS, from a non-legal perspective, when we talk intellectual property, we are talking those the intangible assets that companies have that, in layman's term, I call it part of one of the ingredients in their secret sauce. It is what makes a company go, is what helps them generate their revenue, whether it is the shape of a Coca-Cola bottle, whether it is a color scheme that identifies you you are at Home Depot or versus Lowe's, or whether it is actual source code or documents or customer list or information themselves. All of those items can be considered intellectual property for a company that is something that they've invested time, effort, and money into creating and ultimately needing to preserve.
And absolutely, Teddy. And I think that depending on the industry, each company would consider a particular item an intellectual property, their intellectual property. Most certainly would not want to see it leave, and they want to see it protected, and they take steps in order to do that. But you mentioned the Lanham Act. For non-attorneys in the room, can you describe what a Lanham Act is? What are the premises behind it and how it's related?
Absolutely. So Lanham Act is sort of a colloquial way of talking about the Trademark Act from the 1930s, I believe, that talks about what constitutes a trademark and ultimately how those trademarks are protected. I kind of use it as a shorthand for when I talk about things that would fall under that act. And many times when there are legal filings or complaints filed that are about trademark or trade dress infringement, they will be filed under the premise of the Trademark Act, but it also is called the Lanham Act. And I find it quicker and easier to say Lanham Act than it is to say Trademark Act sometimes, because I feel like that encompasses trademarks, trade dress, copyrights, things that are just more than just straight trademarks. But that also helps govern the work that I do in forensic accounting and understanding what is required for a company to make a claim to recover damages should they actually have had their intellectual property breached or misappropriated, and they suffered harm based on that. But we will get to that in a few minutes. But before we jump into damages of what the damages, financial damages are, should that happen, Mike, I wanted to ask you. The first part of that equation is intellectual property has to be created. It has to be discovered that it might have been misappropriated. Maybe even has to be determined that it is intellectual property of a company, although some of that might be to the nature of the lawyers to have to determine. in today's world in which generative AI is capable of producing just about any digital media, whether it's image, video, voice, or documents, how are you and how is iDS tackling and determining what blurs the line between what is uh, generated AI and what is actually potentially copied, actually copied, or just inspired by some company's intellectual property?
Well, it's a great question. And in my mind, a document or a photo or something derivative that is generated usually does not stand on its own. There are, actions that have to be taken in order for something to be generated, transmitted, uh, you know, sent outside the company, similar things. So, for example, if you're using a generative AI tool, those tools are used by a user. You don't tell AI to go tell AI to go tell AI. We're getting there, but not quite. We're at a point where a user would need to have some sort of a source. They would need to use a device or a computer or a browser or an app in order to access a platform that allows you to generate content. You have to type a prompt. And a lot of that activity is what we would call forensic artifacts. Um, the generation of a document or a picture would have metadata in it. Uh, Something that what I would call a non-generative document or non-generative item uh, would also have, but the metadata would look different. And we would look at the metadata and we would identify the metadata, and you can compare it from documents that are generated by a user as opposed to documents that are generated by, an AI platform or a tool like that, uh, and identify what the differences are.
Now, we've talked about metadata and you've talked about that. And in the role that you have played in some of these investigations, what is the importance of the digital forensics aspect of determining and identifying that metadata as opposed to receiving PDFs in Discovery or documents or copies of documents in Discovery or pictures of images in Discovery versus getting original documents through something like digital forensics?
Well, very often what happens when we receive documents in Discovery, you will have um, not the original, so you might have an image of a document, right? And some of the underlying very basic metadata may be there. You might have um, a date and timestamp. You might have, the name of the document, the path of where it came from. But in many respects, documents, emails, and the like contain metadata that's not visible to a user. They are things like layers in the PDF or what was the producer that was used in the PDF. The underlying PDF might contain metadata that would show that a touch-up tool was used, for example. An original email may have information about date and timestamps that are in the headers of the email, but are not necessarily visually available. And so, in order to inspect whether something is legitimate or not, we very often rely on information that's not readily available to the naked eye. We use tools, we use expertise and analysis to dig much, much deeper to determine the origin of those particular documents and emails.
Now, there is, I think the obvious way that you and I know of, and that most people know of, is IP deliberately being misappropriated, documents being taken on someone's last day, documents being shared outside of a company, or things like that. Are we seeing more instances with open source AI where information and even information, as you said, that maybe the users can't always see is being shared out in a way in which it could be accessed inappropriately in an outside environment from the corporate security?
Yes, and it's actually a very interesting use case because AI is an interesting platform that allows you to help you write a better letter, right? It helps you take the content, give it, and then make it, snazzier, for example, or tone it down. So there is nothing stopping users from pasting a table of very sensitive pricing information and asking ChatGPT or another platform to generate an image based on that, or being able to put in a document that contains SOPs or standard operating procedures for a company that developed them over years and years of experience, and saying, "Can you make it a little funnier?" Uh, and then all of a sudden getting back and then saying, "Can you save it as a Word document?" And all of a sudden, the original doesn't look like the new creation. And then so you can take that document, the watermarks that users or companies put in for compliance reasons and for data leakage are gone. And that particular data or IP is now transferred out in the regular course of business. Now, there are also monitoring tools out there, and you still shouldn't stop using the same monitoring tools for looking at people sending emails to external email addresses, accessing, questionable websites or for file transfers and the like. But what goes out there is a different story, right? It may look like a W-9 or a W-2 form, right? Um, and then with one page actually looking like a company document.
Now, do you see that the legal community adapting or keeping up quickly enough with the speed of technology to keep pace with these risks that we've been discussing with IP leakage through potentially artificial intelligence or open AI?
I think we are, as a community, trying. I think we're really, really trying because we need to catch up. But I think the short answer is no. We're certainly, um, as a group of people, love playing with the technology, but not really. We're still far behind the ball on where the rest of the world in actual use of it to um, do everyday business and conduct nefarious activity. Have you seen something different or
No, and I've done some other presentations for the Bar Association with lawyer colleagues of mine, and without playing lawyer, without getting into the specifics, I do know that the American Bar Association has talked about changing some of the model rules for both acceptability of evidence and digitally created evidence, as well as some of the ethical responsibilities about the use of AI. But these things are still in the model rule phase and have been for months, and probably still will be in model phase for months. And when I've done some of these other continuing educations for lawyers with other lawyers, the typical response of, well, have they thought about Gen AI? Have they thought about there some other forms of the new AI technologies that are coming out there? And the short answer is they're just trying to understand how lawyers are using ChatGPT or how lawyers are using the AI tools within Westlaw or Lexis that companies are using. I think or law firms are using. Um, I don't think the legal community has said they're trying. I don't think they are moving as fast as the technology is moving.
I was curious, and this may be sort of off topic, but maybe relevant. Does AI or the use of AI in generating intellectual property um, affect you as a damages expert?
That's an interesting question. I think it in a way, yes. Indirectly, yes. Directly, no. And I say that in the sense of my role as a damages expert is to understand the link between the action that an individual took or a company took that might have infringed on the intellectual property of another individual or company. And as long as that there's a link that's established by some action is infringing on another company's intellectual property, then that is sufficient for me as an expert under the rules of the AICPA, or the American Institute of Certified Public Accountants, to say, I understand that this causal link exists. I understand that the relationship will be established through legal means or through forensic means or some other means that is not financial in nature, and is not my financial responsibility to say these numbers are directly tied to this action, but it's to say this action is tied to this other action, caused this breach, and now I'm analyzing the numbers that are affiliated with those two pieces. So indirectly, if AI is causing confusion, or AI generated items is causing confusion as to what is true IP or not, then yes, it has an impact on the causation arguments that the lawyers that I'm working with will have to navigate, and may impact what part of the intellectual property that I actually am looking at and making my determination. But directly, I'm not making that determination myself on the AI created items.
Right. And when you're looking at enforcement and you're brought in, you may have, there are companies whose revenue stream is very direct. They only do one thing. That's where they're, mom and pop shops. That's where the revenue is going to come in from. But what happens when you have companies where damages involve multiple revenue streams, and they're really coming in from various business lines, and it affects different, the loss of IP is affecting a number of things. How do you parse that? How do you parse what's attributed to somewhere, tell us what your approach is.
So I view a calculation of intellectual property damages, and I'll go through in a second the different ways in which a company can recover or make claims for. It is very much like a carve out of a business segment, like in an M&A transaction. It is really trying to typically take a slice out of a company and say, what revenues and what expenses can I attribute to this slice, to this product, to this client list, to this likeness. And so in the case of, let's say we're like talk about the shape of a Coca-Cola bottle, that may have a much broader slice, so to speak, of damages if that were to be infringed, than simply just a source code for a specific SaaS product that someone misappropriated and used, and then created a competitor SaaS product for it. It would be very product specific, or very sort of aspect of that product specific. But it is hard to say if there is a very small piece of the whole. So that the code that I discussed. So if a very small piece of source code is taken and is used in a broader product, we still may just have to look at the broader product and the financial results of that broader product. Then if that code is not responsible for generating revenue or expenses, but it is part of that secret sauce that makes the product tick, that makes the product special, unique, marketable, sellable for a margin to a company. Now, when talking about damages, recovering under the Lanham Act, the main ways in which damages are recovered are either a company's lost profits. So I am software company, you have stolen my source code. That product, that software has now turned in from a $1 million product to a $300,000 product because you are now competing with me and are taking my customers, and I've lost money on that. It is through the legal means that is going to be established that loss can be tied to the theft of property. But from a financial means, my job is to determine damages of that revenue less less saved expenses, or those expenses that aren't incurred because you're not making those sales. So to try to get to that bottom line number of how has the damaged party been hurt in their pocket, so to speak, not just revenue, but what are they feeling in their pocket. The other way to look at it is from the infringer side, to either disgorge their revenues or their profits. And so I mean by disgorge, the concept of disgorgement is to say, you infringing party, I may not have specifically lost $10, but by you inappropriately using my intellectual property, you have wrongfully gained dollars. And you don't have the right to gain that $1 million because I have protection on my property. And so the ways in which you can attach damages to that is to say, A, me as the harmed party could have earned that $1 million in revenue, and what would be my cost associated to that so that I could understand how much that hurts my pocket by not earning that $1 million. Or B, you earn that $1 million in revenue, in reality that hit your pocket by $300,000. You were unjustly enriched by $300,000 for using my property, and I'm going to ask for that money back, so that you don't gain from using something that was wrongfully obtained.
Right. That makes sense. And then you mentioned, a particular example, like a source code or one type of information. And is that something that you would analyze yourself? In other words, you could say, well, this source code is substantially similar to that one. Or would you then work with, a forensics expert like myself, or to be able to make that determination and make a reliance on another expert's determination?
Absolutely reliance on another expert. So as a financial expert, we have certain guidelines into what we can make claims on in terms of that establishing that causal link. But we have specific guidance from the CPA that if that causal link falls outside of the financial context, so if you're talking about source code, you're talking about an image, you're talking about the metadata behind something, that's something we would definitely rely on someone like you or our forensic team, or someone who's an expert in marketing and advertising who can talk about things that are creating customer confusion or are reasonably similar.
One thing that I often hear when I do the investigations from clients is their willingness or their desire, I should say, to really go after those who took their intellectual property. Let's go get them. Is there really how would you advise them on, for example, does it make sense to go for damages? Does it make sense to go ask for that as opposed to injunctive release and relief, or maybe talking to them about licensing, right? The recovery of that money in a different way?
That's always one of the first conversations I like to have with both counsel and the client. And it's not my role as the financial expert to play business advisor. And so I try not to give business advice, but I try to lay out the factual reality of what it is that I would do and ask the questions to that for them to then make the determinations on some of those aspects that you're talking about. So for instance, if something has leaked out through OpenAI and was now in the LLM of ChatGPT, that may be too far gone to put a injunction on you to stop its use. Maybe not. I don't know how strenuously that's been tested. But sometimes things are so far gone into the market that the ball's too far out there. So something like injunctive relief is not possible. And so those are the situations where I would either talk to them about what damages look like for recovering past damages, or what a model looks like for saying, well, we can either stop you from using this further, so you can no longer sell this product, but clients still have it, so you can service it. But what's a reasonable royalty that we can make a claim for, so that all of your future revenue is we get a benefit of the fact that we created this, and now you get to use it, and so we should benefit from a market rate of creation for an intellectual property asset such as that. Now, the conversation on damages always comes down to how much do they really want to go after damages, understanding the cost of litigation. Many times it's helping the client understand, to get it to the point where they could make a claim for damages, there's a cost associated with that, what that might look like in terms of recovery. And in a lot of states that there are doubling and trebling of damages for these types of damages in the calculation. So that helps that quantification, that dollar figure go up higher. But is that even available to recover should they win? Many companies just want the injunctive relief. They want a company to stop using what they're using. Coca-Cola, Home Depot, companies like that may or may not benefit from trying to recover money versus just saying, just stop using what you're using. We didn't lose anything because no one's going to confuse mom and pop soda that has a bottle that's the same shape as ours with Coca-Cola, but we don't want you further infringing on it, so we're just going to tell you to stop. I don't know that for a fact that's how Coca-Cola operates, but just in my example, that would be a conversation that we would have is the importance really to take all of the pennies that mom and pop soda earned, or is it really just to get them to stop? And so those are all the conversations that have to be had early on, and those evolve over time as companies determine, how much did I lose? How much did they actually gain? Am I better just saying, here's a slap, please stop it? Or is there something that is worthwhile for me to recover in addition to having them stop, or what is actually the option C, the third door of this scenario is you can't stop it. You've already been harmed. So you can actually recover past damages up to a certain point. So a company can recover their lost profits up to the point of trial, and then can actually put a plan in place for royalties from the date of trial forward. And so it's using two different damage theories, but that's the point where when you can't stop that train from it's already left the station, you need to recover from the past and you need to recover from the future. There is that you can make that stopping point in the middle, and you can do two different damage theories on both ends of that spectrum.
That's actually very insightful, and it's great to see sort of the next step of what I do, what my team does. We'll often come in on the initial end, right, and be able to prove that an IP theft or data was taken, right? Like someone has your information. We rarely see what happens downstream from that. So this has been kind of an incredibly informative conversation for me. Is there anything that, if you were to kind of close out and want to have maybe one thought, what would you want to leave our listeners with in terms of damages and sort of the new landscape?
I think what I want to leave the listeners with is to say IP is more than just those things that I've talked about that are really obvious to everyone. It's more than just the logo of somebody. It's more than just something really obvious like the shape of the Coca-Cola bottle we keep talking about that is in a secret vault down the street from me here in Atlanta that with the recipe. It is those elements that are the secret sauce of what it is that a company does. So it could be R&D that leads to a new product. It could be like I said, source code behind a SaaS product. It could be even just industry knowledge built up over time, kept on an Excel spreadsheet that is just sitting on a shared server that everyone kind of accesses and goes, oh, this is our version of we've learned this stuff over from customer A and this stuff from customer B, and we've collected it all in here, and this is how we keep our relationships going.
Yeah.
It's not something that you've necessarily page created, it's something that's just comes about over time, but really is the backbone that drives a lot of a portion of a business.
And even within a company, medium to a large size company, IP looks different within the company itself. For one section, it may be customer lists. In another, it may be pricing. In another, it may be R&D. Right? So depending on which employee or which section of the business that data leaves from, the determination of intellectual property is going to look completely different, right?
Yeah. No, I think that's a great point, and that's why getting you and our team here at iDS in early and helping identify what those artifacts might be, what those items might be, and the movement of those things where they've gone, is critical, I think, for in minimizing the damages and hopefully providing the information to the companies and to their counsel in having successful defenses of their company's intellectual property. And I think with that, we've reached the end of our iDS talks. I thank everyone for their time. I thank Mike, especially for your time as well.
Thank you. Always a pleasure being here.
Thank you. My pleasure. Pleasure is all mine in the first time. We'll do this again another day with another interesting topic. But if you have any more questions on iDS or the Lanham Act, please go to idsinc.com and you can find information on how to contact us and some of the work that we have done. Thank you, everyone.